want the homeowners in KC to call me for anything they need. I'm here to answer all your questions, teach you some lessons, keep you from stressing, something like a best friend. If you're in KC mode, if you're a homeowner in Kansas City, well, I'm here to let you know that I got you. I'll always be right here. I'm David Lopez. Trust a beard. When it comes to roofing, gutters, and siding, Blue Rain Roofing and Restoration is here for you. Now let's get to today's episode.
Hey Casey, what's up? David Lopez here with Blue Rain Roofing and Restoration. Thank you for watching another episode of Trust the Beard. Today we have a very special guest with us. His name is Jason Rew, and he's with Oswald, Rome, and Rew Law Firm. Is that correct?
That's correct.
I said it right. So today we're going to be talking about, I think the majority of us is going to be talking about liens. So Jason's going to hop on here in a second and just give us, whether you're a homeowner or a contractor, some good tips on the lien process, and maybe talk about the importance of the contract, having the correct verbiage and that kind of fun stuff. So Jason, I'll let you hop on and introduce who you are and what you do.
Sure. My name is Jason Rew. I'm an attorney. I've been practicing law since 2000, so 21 years. I'm with the law firm of Oswald, Rome, and Rew. We're a general practice firm in Blue Springs. I specialize in litigation, particularly with regard to real estate and construction law. And that's the reason why I met David, was through my practice of representing companies like his, particularly in doing things like this, which is trying to file and protect liens on behalf of contractors. And so just to give you some idea of what I'll talk about today, I'll talk a little bit about some of the things I think contractors should do to protect themselves, and that includes the lien process, but is not solely part of the lien process. For example, with any contractor, I tell them, everything must be in writing. We've gotten to the point in society where we do a lot of things by text messaging, and while that's not terrible, it's not ideal. I would encourage contractors, if you're going to do a contract, have a written contract. It can be electronically sent to the client, but it should also be in writing, and there should be a contract that's been signed. Text messaging may be the way that people communicate, but it's not ideal for legal purposes, because at some point in time, a lawyer may have to provide that document to a judge to prove that the parties knew what was going on. And it's really hard to explain to a judge what was going on using 25 or 30 digits as opposed to a contract. So I think all contractors need to operate on the assumption that if it's not in writing, it doesn't exist. And that means a written contract with signatures by both the contractor and the party. There are things that you'll want to have in your contract that are critical to liens. For example, in Missouri, you have to have the lien notice language. That's in a statute in Missouri. If you don't know what that statute is, a lawyer can tell you what that language is, or you can try to find it yourself, but it won't be real easy to find. But basically what that language does is it warns a homeowner that their property could be subject to a lien if their contractor does not get paid. And that has to be in there. Another thing I always tell my contractor clients to make sure is in their contracts are language that allows for attorney's fees. Contrary to popular belief, attorneys don't work for free. And so when the contractor gets the bill from their lawyer and says, well, why am I paying you to represent me in this case? We can say, well, it's because we're doing something to benefit you. But we can also say, hey, there's a possibility we can get my fees back from the party who's in breach of contract. But at least in the state of Missouri, to do that, you have to have a written contract signed by both parties that agree that a prevailing party, in this case, the contractor, would be owed back their attorney's fees and costs, which would include things like filing fees and deposition fees. Another thing I think is good to have in your contract is alternative dispute resolution language. They call that ADR for obvious reasons, but that's things like mediation. What is mediation? That is something that says, hey, if there's a dispute over the contract and the parties can't agree to what is owed or isn't owed, the parties can then get together in an informal setting. We call it mediation, usually with a mediator, who's usually a lawyer, sometimes a former judge, and they try to work out the disagreement informally before anybody runs to the courthouse and spends a bunch of money trying to file suit. With regard to things in the contract, I always think having certainty and specificity is critical. Don't just go over and bid a job and say this is the amount without explaining how you came to that amount. And I say that because you may be thinking one thing and the homeowner may be thinking something totally different. So I would say put detail in your proposal, detail in your contract. Fixed costs are better than unit costs, because a lot of times people have one thing in mind as to what it's going to require. Somebody has something else in mind. So a fixed cost is best. If you have to have contingencies in there, I understand, but I would make sure you spell out those contingencies. If you are, digging a hole and you're not sure if you're going to hit rock, you obviously want to have something in there that says, hey, if I dig this hole and I hit rock, it's going to cost you more if I got to blow it up with dynamite. So contingencies are okay, but avoid them if you can. I think the key when you enter a contract with a homeowner is to make sure both sides feel comfortable asking and answering questions with one another. And sometimes those questions are best to be asked and answered through email. So there's a document that says, we talked about this and you asked about this and I told you this about that. And that brings me to my last tip with regard to entering a contract, which is keep all documentation forever. There's no reason to get rid of it. Keep electronically, whether it's emails, even text messages, which I don't like, but even if you're going to have those, keep them. Any letters, anything like that, keep it, because at some point in time, if you end up in court, a lawyer is going to ask you for all of your documents relating to that project, and you don't want to say, well, I threw them all away after the project was done. A couple more things with regard to work being performed. Make sure you're supervising your employees' work. Make sure you are asking and answering questions that are raised during the process of the job. Take pictures and video of your work, especially if you have a client who is not being particularly easy to work with. If they're complaining all the time, and maybe those complaints are justified, maybe they aren't, you or your crew or your foreman videotape, photograph the process, because at some point in time, what you have in those videos, particularly if you're, for example, putting on a roof, once that roof is on, unless you want to take the roof off, we can't tell what's underneath there. And there's a question as to what's underneath there. It's better to have a video or a photo showing what was underneath there before the roof goes back on. So always document your work, but particularly if you have somebody who you think is going to be a potential problem down the road. I'm going to talk about payment, and then I'm going to talk about mechanics lien specifically. But payment, do not expect all of your jobs to be paid in advance. That's not something that happens, and it's probably not something you should ask. You may want to request a draw for supplies before you begin. You may want to request draws as the work is performed. But if you're going to do draws, you need to provide the homeowner with an itemized invoice as you submit those draws. That way they know what they're paying for. They're paying for this portion of the work or that portion of the work. And there's no confusion that as the job goes on that they didn't pay you everything. They only paid you for the first X portion of that work to be performed. And then ultimately when the job is completed, you want to provide the final invoice, again, itemized. And you also want to provide a couple things to them with that. One thing would certainly be a lien waiver. If you don't know what a lien waiver is, you probably should find that out. That's important. But basically, it tells the homeowner that they can't file a lien against you. I'm sorry, that you won't file a lien against them. I said that backwards. You want to provide a lien waiver saying that you won't file a lien against them, so they have that assured. And then, of course, you would also want to ask them, I think you'd want to ask them for any feedback at that point in time. And the reason why I say that is if you've talked to them, they're satisfied, they paid you, you've submitted a itemized invoice, you've submitted them a signed lien waiver, there really should be no issues. But if there are any issues, you want to find out before you leave the job site what those issues are, if they're unhappy. And if they're happy, I think in this day and age, you want to ask them to let other people know that they're happy. Do online reviews, post something on Facebook, tell a friend, tell a neighbor, tell a family member, you like the roof I did, You know, you might sell 10 more roofs because of one happy customer. And if they aren't happy, you need to figure out what's making them unhappy, and you need to fix it, because it's going to ultimately be more of a problem down the road if you don't fix it, than ignoring it. Mechanics liens. Hopefully, you'll never have to file one, but if you do, my first bit of advice, I think, is the most important advice, and that is hire a competent construction attorney to file one for you. I see in my cases all the time cases where contractors have filed their own liens, and while I give them credit for trying, they're typically flawed. And a flawed lien in the long run may be worth nothing. I would hire a competent construction attorney. The cost is certainly worth whatever it is, because you're not risking, or at least not risking, the high degree of uncertainty that you're going to have if you filed yourself. However, with mechanics liens, there's a lot of distinctions. Missouri liens are different than Kansas liens, so know where you do the work, both by county, but particularly by state. Commercial liens are different than residential liens. Single-family residential is different than multifamily residential. So if you're working on apartments or duplexes, there's a distinction. Existing home renovation work is distinguished from new construction in certain places. Being a contractor, first-tier contractor, is different than being a subcontractor. And I say all of this because there's a lot of deadlines with liens. You know, in Kansas, you're going to have between 3 and 4 months to file your lien. In Missouri, you're going to have no more than 6 months. In order to know how much time you have, you need to know what you are and where you are. And if you don't know what you are and where you are, you might miss your deadline. If you miss your deadline, then you won't have a lien. In Kansas, you can extend your deadline for filing a lien. In Missouri, you cannot. And there's notice requirements. We talked about that a moment ago, providing the written statutory notice in Missouri that if you don't pay, or if it isn't paid, then there's a risk of having to pay twice to a homeowner. But no matter where you are, whether you're in Kansas or Missouri, you're going to have to eventually, if you don't get paid, file a lawsuit in court to perfect your lien. And that means a couple things. It means, number one, you're asking the court to validate that your lien is good. You're asking the court to determine priority, meaning who has priority amongst various contractors, taxing entities like the government, mortgages, or anybody else who has an interest in that property. The court has to make that determination, and that's based on statute in that state and all those other factors I talked about. So priority is the second issue after they establish whether you have a valid lien. And the third issue would become forcing the sale of the property to provide the proceeds to pay off the lien claimants like yourself. What I will say about the lien process, it's timely and it can be expensive, particularly with regard to paying attorneys. But the reason why I still encourage people to do them, it is the only way as a contractor you'll have leverage to get paid. Most people don't want to lien on their house, and if they go to refinance their house at some point in the future, or if they go to sell their house at some point in the future, that lien has to be addressed, even if you never did pursue perfection of that lien. So it is the one way you can get paid, better than other ways. There are a few other ways I'll note here in a moment. If you didn't file a lien for whatever reason and you think, well, it's too late, I'll never get paid now, that's not true. Just because you missed your deadline to file a lien doesn't mean you won't get paid. It just means you won't have a lien. You can get paid other ways. You can file a lawsuit for breach of contract. And that lawsuit can be filed in Missouri, we call it Associate Circuit Court or Circuit Court, in District Court in Kansas. You can also file, if it's under $5,000, you can file in Small Claims Court. If you are an LLC, at least in Missouri, you cannot file yourself in Associate Circuit Court or Circuit Court but you can file on behalf of the LLC in small claims court. So that's one advantage you have in small claims is anybody can file, but it's got to be under $5,000. If it's more than $5,000, the court will reduce your judgment to that amount. One other way is if somebody writes you a bad check, for example, you have the right to pursue restitution through the prosecution process. So if you have homeowners who've done that, that's another way to get paid is through restitution. But obviously, none of these ways are simple, and that's why I suggest that, if you're going to find yourself in a position where you need to pursue collection, you hire a lawyer who does this kind of work. It won't be free, it might not even be cheap, but ultimately you might get more recovery than you would otherwise get than, just sitting back and trying to do it yourself.
For sure. And I got some things to go over with you real quick. Did you have anything else you want to touch bases with that? Or?
Nope. That was everything.
So you talked about documentation. Documentation is of course huge, especially for us. And I think documentation, like you talked about, starts from the beginning of the job. Just photos, videos of before, during, progress, and after is always great. And then that also leads to documentation on what type of contracts you have. I know you helped me out when I first started. I brought in all my contracts and all that fun stuff, and we kind of went over them, and you made sure we had the proper verbiage in there to make sure we were able to file a lien if that happened. You also made sure that the attorney fees were in there, mentioned in our contracts. You also made sure that, I believe you made sure that the interest or rates or percentage amounts or something were reasonable, not too high, because I know that in court, if they're too high, they could throw that out or whatever the case may be. So I know you really helped us out with that part. So guys, if you're watching this, whether you're a contractor or whatever the case may be, documentation is huge from start to finish. Before and after, and progress videos, and of course your contracts are huge, and that's something Jason can help you out with if you need that. I also wanted to talk about, you talked on it a moment, in Kansas, how much time do we have to file the lien? I know you said it's kind of estimated, but
It's between 3 and 4 months, depending on who you are and what you're doing. There are different types of categories. I mean, I can just show you. I got a binder that I use that has all different types of situations. So, but I can tell you, in Kansas, we call it a short. It's got a very short deadline. 3 or 4 months. In Missouri, it would be 6 months.
6 months in Missouri, and you said Kansas will give you an extension.
You can request an extension in Kansas. You cannot request one in Missouri, right? Yes.
And that also leads me to I think it's a 10-day notice requirement or something.
That's in Missouri. 10-day notice requirement in Missouri, right? So in Missouri, you got a little more time in Missouri, but you also have an extra hurdle to get over, which is filing your notice of intent, which is a right to cure. That allows the homeowner to cure the lien. In other words, pay the bill before you go ahead and file your lien. So
and they have to receive that 10 days prior to, I guess, would you call it the 60th day?
The 6 month deadline.
6 months. Sorry.
Yeah.
So they have to receive that.
So it's 6. Yeah. So that would be 6 months minus 10 days.
Sorry. Yeah. My bad. I was thinking. Yeah. Yeah. I'm crazy.
And you can tell from this exchange how confusing it can get when people try to do it on their own, because there are rules, but there are exceptions. And then there are exceptions to the exceptions, which is why you really want to make sure a lawyer looks at this and make sure you're doing the right thing and not rely on what somebody else told you at the job site or what you saw on the internet. Those are the things that we hear people doing a lot of, and it kind of does get them in trouble sometimes.
Well, and not only that, especially with COVID going on. So there's been a couple of times that I was going to have Anna in my office go do them.
Yeah.
I was like, hey, let's just try it out. And it was a nightmare. It was.
Yeah.
There's just, so in our case, we got other shit we need to worry about. Right. So we hire a professional to take care of that for us. So,
exactly.
Once you file the lien, does it expire, or is that for life?
No, it does expire. Well, it does expire in terms of what your timing is to file suit. So, like, for example, in Missouri, you have 1 year to file a lawsuit to perfect your lien. However, if you don't file your lawsuit, that lien will stay on that property forever. Mm-hmm. Now, what happens with that lien is maybe subject to interpretation, because if somebody 5 years later goes to sell their house and they discover that there's a lien that's been lingering out there for 5 years, and either they knew about it and they ignored it, or they forgot about it, or they didn't know about it, they got to figure out what to do with that lien in order to either refi their house or sell it. Now, what they could do is simply go to the contractor and say, remove it, because this lien is slandering the title of my real estate. Or they might, if you're lucky, come to you and say, okay, we're ready to pay this thing off now, even though they may not have a legal obligation to, because the lien has technically expired. So that's why I say it does provide you some leverage, because if somebody's getting ready to sell or refinance, the title company will not insure title without having that lien either paid off or an exception to title insurance written around it. So the answer to your question is, if you file the lien or you have a lawyer file the lien, yes, you really have a time limit to follow up and get the lawsuit on file.
Okay, so file the lien, and then you have, once the lien's been filed, you have a year to, you call it perfect it?
Yes.
And then
Which is file the lawsuit to enforce it.
To enforce it, and at that point in time, does that expire or no? That stays,
No.
let's say 20 years down the road, we're still in business, and this old guy passes away, whatever the case may be, or they finally sell their home. Do we still get it at that point in time? Or
once you file the lawsuit, the court's not going to let you spend 20 years, in their systems. So that's not going to happen.
Yeah, that's what I'm curious.
I mean, once you file the lawsuit, you're going to be in the courts. You're going to be in the court's system, in the jurisdiction of the court, and they're going to make sure you move this case along quicker than that. So that
I wasn't sure how all that, of course, and that's why where you come into play, because you know all that fun stuff. So
yeah. So they'll make you. Something will happen sooner rather than later once you file your lawsuit. It's the people who file a lien and then don't file a lawsuit that can linger for 20 years.
Got it.
And that's the situation I explained a minute ago, where technically the lien is no longer valid because you never perfected it.
Okay.
But the property owner still has to get rid of you one way or another in order to transfer title to their house.
Okay. Now, you touched a little bit about this, and I think you've helped us with this too in the past. The time for lien has passed. We're 6 months and 10 days in. We can go to the next step, as you talked about small claims court and things like that. So you kind of went over all that. Is there anything, you don't want to get more detailed into that, do you?
Yeah, and those are just alternatives to filing a lien. I mean, if you don't want, let's say you're owed $3,000. If you call me up and you say I'm owed $3,000, I'll probably tell you I can file a lien for you, but I don't think it's probably a wise use of your money, because I'm going to spend more than you're going to get back. And oh, by the way, we have these things called small claims courts that you can walk up to, fill out with your handwriting a petition, and you're going to have a court date in a few weeks, and either they're going to show up and the court's going to hear a trial, or they're not going to show up, and then you just take your judgment. So, we like to look at the value of the lien. A lien is valuable, but it's not worth pursuing a lien for a case that's under $5,000, under $3,000, somewhere in that ballpark. It just doesn't have
not
value.
Got it.
Yeah.
And you also touched a little e-sign. So I know we, like for instance, in our company, we use e-sign pretty much on everything now.
Perfectly acceptable.
It's okay. Nothing's, because I know before they sign it, they have to click confirm on a little disclosure thing, whatever the hell. And then so that wouldn't hold up in court saying, well, I didn't know what I was doing or something like that, or any of that crazy stuff.
No, I mean, I think DocuSign, e-sign, that's kind of the way things are now, real estate. I mean, if you buy a house tomorrow, you're probably never going to sign your name. You're just going to do DocuSign. So no, I think it's totally permissible. I mean, the big thing though is I do encourage you though, don't just email them a contract and not tell them what it says and ask them to sign it. I mean, I think you need to go over with your customer. This is what I'm charging, and this is what you're getting, and here is a contingency or two, and that way you've also had that conversation, because we like to assume people read what they sign, but they don't. So I think you should go over with them verbally at least the main points, and then also make sure they sign it and send it back on their own. Again, I think with contractors, especially unsophisticated homeowners, which most homeowners are going to be unsophisticated to the construction process. I think the key is communication. Talk to them. Let them know what they're getting. Let them know what you're providing. Let them know what they're paying. And you'll save yourself a lot of trouble down the road. there won't be any surprises that way. And I think they'll appreciate that in the end too.
No, and that's correct. And we got the 4 ION words, I call them, that we kind of live and die by around here. And the first one starts with education, which is huge for the company and all your reps, making sure they're completely educated. That way we can educate our homeowners on whatever services we're offering. And then, of course, that goes into documentation, like we talked about. Documentation starts from the paperwork to photos, before, after, during, progress jobs. Also, expectation is huge. Just letting you know the good, the bad, and the ugly. And, of course, communication. So those 4 words are huge. I think in any business, as long as you keep that on every process, it's just going to make sure you're crossing your T's and dotting your I's on everything. So,
and one other point on documentation, you talked about the having in a we talked about having in writing and taking photos and video. One of the reasons why we do this is the judicial system that we operate in moves rather slowly, and you might provide a product to a client in June of 2018, and you might not see the inside of a courtroom until April of 2020. And by then 2 years has passed, and have memories faded? Absolutely. And so we want to make sure we have the photos and the video and the documents to support fading memories, and that way there's no question what it looked like or what it read or whatever the case might be when it finally goes to in front of a judge, a year or 2 years later.
Very true. And one thing we've noticed is having a good accounts receivable system in place. Because a lot of times the people that aren't paying us aren't because for whatever reason the job went south or something. I think we've had one of those, but a lot of the other times it's just because lack of invoicing, lack of getting them out on time, lack of, I always call it motivating customers to pay. And so I think what we've kind of done, and I'll just run through what we do real quick. So I think you've been tagged in it, is we have a 15-day reminder, a 30-day reminder, and a 45-day reminder. And if we don't get nowhere between that 15-day and 30-day, I think Anna's done it where she tags you in an email stating, hey, this is our last reminder. Our next step is moving on with the lien process. And then we send a certified letter also along with that. And I think we've done that once or twice, and that's really helped. I always call it motivating the customer to pay. So
yeah, and it avoids a situation where the customer says, well, I never knew I was even billed. I never saw an invoice. Well, you saw it 3 times. And oh, by the way, our lawyer was copied on the 3rd letter and he got it. So it takes away that argument that I just never knew what I owed. And that's what a lot of times people will say, well, I just didn't know. Well, you probably knew, you just didn't want to pay it. But
and so that's usually what we've experienced, is when we have someone not pay, is just because we either took too long, and then I think sometimes it just gets so long, and a lot of it could be insurance work where we usually have those issues at, and people are getting these large checks in their account. They're not used to having that type of money for a claim. And the next thing you know, Christmas is around the corner and they're spending a little bit of dough. And so, usually before Christmas, I always tell everybody, hey, we need to collect. Or giving time. I'm like, this is the time, especially their insurance jobs. We don't want those large checks sitting around in their bank accounts. So any tips for homeowners? I know we've talked a lot because you do a lot with contractors. Just something, I get a lot of homeowners that watch this. Of course, they need to do their due diligence, making sure everything's correct, because it's not always, it could be where the homeowner does do something wrong, right? And then they're coming through. So what are some tips just for a homeowner to make sure they're reading the contracts correctly, make sure they understand it, all that? Because there are going to be those contractors that, I've seen a lot where contractors are just lazy. They don't want to take the time to write a good estimate. And then
I think my first tip to homeowners would be hire the right contractor. And by that, I mean, price is always a factor, but it can't be the only factor. You might have a contractor out there who likes to take jobs, but then doesn't like to actually do the work. And you don't want to have, for example, you want a deck put on your house so that you can enjoy it this summer. You don't want to hire somebody who gets you into a contract but won't start the work until December. So you want to make sure you hire the right contractor. And the best way you can hire a good, reliable contractor is to do your homework. I mean, you can. There's a lot of the resources that are available today versus 30 years ago are just drastically better. The first place I would say is look at referrals. I mean, if you have a friend or a family member or a neighbor who was happy with their contractor, I think that's worth more than anything, because that's somebody who is gaining nothing by telling you about this person, but and they wouldn't lie to you. Your neighbor isn't going to tell you their contractor did a great job if they didn't, nor would your family members. But we also have, we have Google now. And this sounds funny, but you might Google somebody who you're thinking about hiring and find out they've been on, Fox 4 Problem Solvers 3 times. Probably don't want to hire that person. They probably aren't going to be good for you if they weren't good for the people who call problem solvers. There's other references out there, beyond Google and the Yahoo types of ratings. I mean, there's Better Business Bureau, AngelList, those sorts of organizations. But just do your homework. Another one is CaseNet. I mean, if you look up your contractor and they've been sued 30 times for doing terrible things, and they're in CaseNet page after page after page, you might want to avoid them. Most of my advice to contractors is identical. I'm sorry, to homeowners is identical to my advice to contractors. Get everything in writing. Avoid contingencies. Go with a fixed cost. If you have a question, ask it. Email it. Get the response in an email. I mean, contractors and homeowners have a lot in common when it comes to making sure they have documentation of what the parties' expectations are. Because if you expected your roof to be one type of material and the contractor expected to be another type of material, and there's a significant cost difference in the two, you want to get that figured out before somebody goes up and starts installing your roof. So you want to make sure that you have everything in writing, and any documentation of communications, you want to make sure you keep those perpetually. Supervise your contractor's work. Make sure they're doing what you think they're supposed to be doing. If they aren't, ask questions. If you're a homeowner, same thing. Take photos, take video. If you think they're doing something that's going to get covered up that doesn't look right to you, you better photograph it and video it before it gets covered up, because you'll never see it again unless you want to tear up the house. This goes particularly with I want to call them the unreliable contractor, the one who shows up one day and then you don't see him again for a month. And that is, you got to be the squeaky wheel. It sounds, if you got that contractor, you've got to be the one who calls and texts and emails every day. Where's your crew? Why aren't you here? Because you want to try to motivate them to get there as a squeaky wheel, but you also want to have documentation that, hey, I called this guy, emailed him, texted him 13 times and he didn't show up. That is something that a judge is going to look at and go, well, why didn't you all show up these 13 days when Mr. Jones was texting and emailing you? A lot of same things with homeowners. Don't prepay the job. Don't prepay 100% at least. That's how you end up, holding the bag when the contractor never shows back up. You may be expected to pay for some materials in advance. You may be expected to pay for draws for work already performed. Make sure it's documented. If you're going to pay a draw, know what you're paying for. I'm paying for what portion of the work? What portion do I have left? Ask for an invoice. What am I paying for? And if he won't give you an invoice, then don't pay it until he gives it to you. And when you pay the balance at the end, now you want to ask for a lien waiver if the contractor doesn't provide you one. And the reason why is you don't want the contractor to file a lien against your property a month after they leave, even though you paid them. And then, like I said earlier, provide feedback if you're a homeowner, both verbally, but also provide feedback online, provide feedback amongst your neighbors. If it's good, recommend them. If it's bad, warn them. This is how bad companies typically go away, is they get enough bad feedback and there's no referrals and they eventually leave the industry. And you could be helpful in that regard. And if they're good and you want them to prosper, then this is what will help them prosper is by sharing their name and the good things you have to say about them and, with other potential customers.
And I'll go on lien waivers real quick, and then we'll end it with this unless you have anything else. So I know there's lien waivers. A lot of people can just look online, find them, whatever the case may be. I'm assuming they come to you. You can help them write up a good for their company. Now, there's a couple different types of lien waivers. Am I wrong? Like there's just a standard lien waiver. Then there's like a conditional lien waiver, things of that sort. I know years ago, I had got myself in trouble because I did not give them a conditional lien waiver. Mm-hmm. And based off what I gave them, it stated that they were, I guess, paid in full and everything.
Sure.
Because they needed, I think, a mortgage process or something. And then so I wasn't able to get that money because I provided that a non-conditional lien waiver, I think is what it was. And I couldn't do nothing about it.
Well, yeah, typically they'll call them a conditional lien waiver or a final lien waiver. And as the name would indicate, the final lien waiver is when all the work is completed and you've been paid in full. A conditional lien waiver is typically when work has been performed but you haven't been paid, or you've only done a portion of the work and there's still work remaining to be done. And so what you want to make sure of, because it becomes a little bit of a chicken or the egg situation, is the homeowner says, well, I don't want to pay you till I get a lien waiver. And the contractor says, well, I don't want to give you a lien waiver until I've been paid. So who goes first? So sometimes what people say is, okay, that's fine. What I'll do is I'll go ahead and give you a conditional lien waiver that says I'm gonna accept $10,000, and once I get that $10,000, then I'm waiving my lien. But until I get that, it's just conditional. And then once you get the $10,000, you can follow that up with a final lien waiver. And all that's doing is providing the homeowner assurance you're not going to come back and file a lien against them.
For sure.
So typically you want to avoid. You want to avoid final lien waivers until you've been paid in full. Everything else would be a conditional lien waiver, or it'd be a partial lien waiver, or something along those lines, because you want to leave yourself the option of filing a lien if in case you don't get paid that final payment. You don't want your partial lien waiver for the first draw to somehow be construed as a final lien waiver. With regard to lien waivers, they probably are available online. You could probably Google it. However, I will tell you, as with a lot of things, every state has its own laws, and these are state laws that govern things like liens and lien waivers. So if you go and Google lien waiver, you may find one that's perfectly fine in North Dakota, but may not have what you need in Missouri or Kansas. And that's why, particularly if you're a contractor, I would just hire a lawyer to prepare a lien waiver for you, and maybe even a partial lien waiver for you. And then that same lien waiver you can use usually on every job. You don't have to have the lawyer prepare one for every job. It's just sort of a standard form. The contractor then fills out the amount and dates it and the property owner's name, and then submits it. And that's all you have to do. It would and should become part of your project closeout process, to where you don't have to call your lawyer and say, prepare a lien waiver. You just say to your office manager or whoever does your books, we need a lien waiver for the Thompson work.
And on top of that, this is for homeowners. I think it's great for homeowners to ask for them, because I've heard of situations where, and I don't know how this works on lien waivers, but let's just say they didn't ask for a lien waiver, right? And that contractor goes out of business a month down the road and he didn't pay his sub or his material bill.
Yep.
And the next thing you know, that sub's knocking on that homeowner's door. Hey, I didn't get paid. I'm going to put a lien on your property, blah, blah, blah. Or he's not answering that sub, or the material supplier shows up or sends a letter in the mail. I think something, because I've seen that happen before too, pending the situation. So when the contractor fills out a conditional or final lien waiver, I know when we'll do them, we'll have one from like our supplier too, and one
Yes.
from our sub. So
Yes.
do you need three different ones, or does one cover all of that? Because I know that depending the customer situation, sometimes they want them signed from each individual. Is there one that covers that whole basis?
Well, like you said, if the contractor, if the GC on the job goes out of business, then the lower tier contractors or suppliers are still going to have the right, at least they're going to try to assert the right to pursue collection through a lien for the work they performed. And so as a homeowner, yeah, you may not be thinking this, but you also have to assume that GC may not have paid their suppliers or their lower tier subs, and that you'd want one from everybody who worked on the project. When you see these schools that are being built, or you see these large, commercial buildings, I can assure you that the person who is representing the owner in those projects are getting a lien waiver from every single person who stepped on to that project, all the way down to the person who supplies, screws or nuts or whatever it is. As a homeowner, it's a little harder because you may not know where the GC starts and ends versus subs and suppliers. So it's a little bit harder for them because they're not going to know that the guy they hired to build their swimming pool used 3 subs. They may just think it's the same company every time. So I have a lot of sympathy for them in that situation. But certainly on a commercial side, if you're the one who's building a hotel in downtown, one contractor isn't doing everything. There might be 50 contractors down there, and you know who they are. And so you're going to make sure you get lien waivers from every one of those 50 suppliers and subs. And as a homeowner, you can certainly ask your GC, do you use subs? Do you use suppliers? They can lie to you, but you also might see trucks in your driveway that have different names than your contractor. And that's certainly a sign that, hey, this guy's using subs or suppliers. And yeah, I would ask for those lien waivers for sure, especially if you think there's any problem with the contractor.
Oh yeah. And in this day and time, 99% of construction companies, roofers, anybody that's in remodel or anything like that, they're using subs. I mean, it is what it is.
Yeah, especially if it's something like a complete renovation of your home. I mean, rarely is one guy going to do everything. He's going to have multiple tradesmen. If it's just something as simple as somebody's putting up a fence, it's probably just one person, something along those lines. But yeah, ask the question.
Now that sub, let's say the homeowner paid the contractor. All right, let's just say the sheetrock sub didn't get paid. He's got a contract between him and the sub got a contract with him, the general contractor. Is that sub able to go now to the homeowner and put a lien on their property? Or as long as he does it within the same steps and has proper documentation, all that, that's still, you can still do that, right?
Yeah, the sub has two different avenues towards collection. One is to sue the contractor for breach of contract because they didn't pay him, and the other is to sue the homeowner either under the lien or under some other theory. If the homeowner didn't pay the general, then they could sue the homeowner under theory of unjust enrichment, meaning you accepted the benefits of my labor and you didn't pay for them. Now, if they did pay for them, then your only theory would be under the theory of mechanics lien. And again, that gets into all kinds of different issues with notice and priority and timing and what kind of, as a sub, what kind of work are you doing? Are you working for a residential versus commercial versus multifamily? And there's just a lot of different questions that have to be answered to determine whether or not you're going to have a valid mechanics lien. But that would be your only option against the homeowner if the homeowner actually paid their invoice to the general contractor.
Awesome. Well, I think we covered a lot. Is there any other extra info you want to add out there? I'd definitely like for you to give who you are again and any contact information. That way people can contact you directly when I get a hold of you.
Sure. It's Jason Rew, R-E-W. And again, the law firm is Oswald, Rome, and that's R-O-A-M. in Rew, and we are in Blue Springs, Missouri. My office telephone number is 816-229-8121. I'm licensed in Kansas and in Missouri. So if you do work in other states, you'll probably need to find lawyers in those particular states. But our firm, there's about 8 lawyers here, and we do a general practice. So we have lawyers here who do everything from domestic family law to business law to litigation, personal injury. We estate planning, so we do a variety of different areas of law. But I do want to emphasize that if you're unsure of what you're doing, it's money well spent to call and hire a lawyer to at least get you started, get you some of the documents, do a contract review as I did with David. That means the lawyer actually reads your contract and says this is what needs to be changed. Prepare things like lien waivers and make sure that when you do find yourself in a situation where you have to pursue a lien, you have somebody you can call who knows who you are, knows your situation, and can pursue that lien on your behalf.
And I recommend it, guys. Oh, sorry. Did you have something?
No, I was going to thank you for letting me come on your show. I appreciate it.
Yeah, no problem. And definitely, I was that contractor once. Tried doing everything on my own. It's just not fun. And you learn a lot, and as you start to get systems in place and all that other fun stuff, you realize that unfortunately, being in the roofing business, we know we set a certain amount of money a year that we know we're going to lose. I mean, we don't know how much it's going to be that year, but there is that we just know we're not going to get paid on it. And now that my wife, Anna, has took over accounts receivable the last year or two, she sees it now and she's like, what the hell? Like, people just don't pay. And I'm like, but having a guy like Jason on your team that knows what he's doing and it can help you get paid. I mean, like I said, having a good accounts receivable system in place is going to help too.
Yeah.
And knowing your times and dates, when you sent your final invoice out, when the work was completed, all that fun stuff is good. So I definitely recommend reaching out to Jason if you ever have these issues, or you're a contractor that's just starting out and this is something you're not sure how to go with. He's definitely good and will help you out with all this fun stuff. So,
All right.
Cool. Well, Jason, thanks for having me, man. We will see you around. Everybody, thank you for tuning in to another episode of Trust the Beard. Have a great day and adios.
Thanks, David. Thanks.
Thanks, buddy.